Foreclosures Section 4. Owners and tenants. Owners. How long can they stay in their house? As the foreclosure proceedings commence, the owners will be served with papers. On the papers are the names, addresses, and phone numbers of the lawyers acting for the lender. These lawyers may give limited information regarding the foreclosure process. They prefer that the owners seek their own independent legal advice. It is always best for the owners to seek information from their own lawyer, especially if they have any equity in the property. A common complaint from owners to listing realtors is that they did not receive any papers and they do not know anything about the foreclosure. The owners must always be served papers as they are party to the foreclosure proceedings. They will receive legal papers as to when they have to vacate. Rights of the owner. The first main order in a foreclosure action is the order nisi. The order nisi carries with it several sub-orders, so to speak. These including the setting of the redemption period, the order for judgment against the mortgagor, the order for costs in favor of the lender, the order for an accounting, and the declaration of default. The redemption period will be between 1 day and 6 months, depending largely on the equity for the mortgage and the condition of the property. Generally, the lower the equity and the worse the condition of the property, the shorter will be the redemption period. During the longer redemption periods, the borrower will have the option of selling the property without the lender's involvement or refinancing it. Also, if the lender will accept an update, the borrower will be able to provide funds to put the mortgage back into good standing. It should also be stated that near the end of a redemption period, the borrower may apply for an order extending the redemption period. If the borrower can show the court that they have a plan to bring the mortgage into good standing, or, for example, are close to selling the property, the court may grant an extension. If the redemption period has been a 6-month redemption period, however, the court will not likely grant an extension. The borrower will have to have good, strong evidence of his or her ability to update or pay out the mortgage. Listing procedure. After the expiry of the redemption period, especially if it has been 6 months, the court will likely grant conduct of sale to the lender. The lender must apply and show evidence that the redemption period has expired and that the lender is ready to list the property. Once the order is pronounced and filed, entered at the court registry, the lender is at liberty to list the property with a realtor of its choice. Usually the lender will first ask the realtor chosen to attend at the property in order to inspect it for the purpose of establishing a list price. Assuming the realtor is able to gain access, she or he will provide a price recommendation to the lender. The lender will then decide on the list price and will then sign a listing agreement with the chosen realtor. If the realtor expresses concern about the condition of the property, or if he or she is denied access, a court application may be required. A denial of access will lead to an application for forced entry, or in extreme circumstances, vacant possession, or maybe the appointment of a receiver. If the property is in poor condition, it may require cleanup and or repair. In such circumstances, an application for receiver and or vacant possession will be required because these circumstances are not conducive to the owner-occupant being able to remain in the property. The listing realtor is otherwise then free to market the property in the regular manner. Tenants. Payment of rents. When tenants realize that the house is in foreclosure, they often wonder where and to whom they should pay the rent. It is always best to have the lender or its lawyers inform the tenants in writing as to whom they should be paying. If there is a reference to an assignment of rents on the title search, the lender will then tell them how to pay. Otherwise, they should continue paying the rent to the landlord. Does the court order override the residential tenancy agreement? the tenant has the right of proper notice to vacate. Under the existing legislation, once a foreclosure action is launched, if the tenant is named as a party to the action, the parties are not bound by the legislation. Rights of the tenants. Tenants' rights are protected by the Residential Tenancy Act. Section 85.4 says that no court order is enforceable against a tenant unless the tenant was made a party to the proceedings. If the tenant was not named and the property is sold, the Residential Tenancy Act must be followed to remove the tenant. This could pose a problem for the new owner. If the property was purchased as a revenue rental, the new owner inherits the tenants in place along with the terms of the existing agreement and the rate of rent being paid. There must be a valid reason to remove the tenants from that point on, and the statutory process for raising rents must be followed. If the property will likely sell as a revenue rental, it will probably be a benefit to the buyer and a selling incentive to have the tenants named. This gives the new owner the option to retain the existing tenants or to have them move and put in new tenants at a different level of rent under a new tenancy agreement. Tenants in place. If the property is purchased with tenants in place and the tenancy continues, the new owner is responsible for any existing security deposit, whether or not it was transferred from the previous owners according to Section 80.11 of the Residential Tenancy Act. Renting the home after service of papers. If the home is rented after the foreclosure process has started, the tenancy is governed by the same factors as previously mentioned, the biggest difference being whether the tenant was named generically in the petition. If the tenant was named but generically, the realtor should inform the lender's lawyer of the presence of the tenant. The lawyer should then apply for a court order adding the tenant as a party to the action. When the lender is granted conduct of sale, the realtor will be sent to the property to inspect it and prepare a CMA to arrive at a recommended listing price. If the realtor is unable to gain access for any reason, there should be a second effort made. This may include a phone call, a written notice, or simply the realtor's presence at the door a second time. After 2 unsuccessful efforts to gain access, the lender should consider applying in court for an order of forced entry or vacant possession. In such an application, a letter or affidavit of the realtor will be needed. The lender's lawyer may ask the realtor to attend in court at the application. Once this order is granted, the realtor will be legally permitted to enter the property without restriction. If the order granted is forced entry, the realtor should attend at the property with a locksmith and change the lock. The occupant will be given a key, as will the realtor. A lock box may be installed at the property as well at this time. If the circumstances at the property are unusual and or hostile, an application for an order of forced entry will be inadequate. The lawyer will seek either an order of vacant possession or a writ of possession. To obtain an order of vacant possession, the realtor must provide the evidence of the circumstances at the property. The lawyer and the realtor must convince the court that the property must be vacant in order for the realtor to be able to properly market the property without interference. In such situations, the occupant is typically attempting to deliberately prevent access, and the realtor would have to alert the lender of the dangers. Once the order is obtained, the lender and the realtor will determine who will attend at the property, such as the police and or a bailiff. Tenant eviction. Tenant eviction is clearly stated in the Residential Tenancy Act as far as sales are concerned. In the event the tenant is not named as a party to the foreclosure action, the Real Estate Services Act continues to apply. Section 49. Landlord's notice. Landlord's use of property. 5. A landlord may end a tenancy in respect of a rental unit if A. The landlord enters into an agreement in good faith to sell the rental unit. B. All the conditions on which the sale depends have been satisfied. And C. The purchaser asks the landlord in writing to give notice to end the tenancy on one of the following grounds. Roman numeral 1. The purchaser is an individual, and the purchaser or a close family member of the purchaser intends in good faith to occupy the rental unit. Roman numeral 2. The purchaser is a family corporation, and a person owning voting shares in the corporation or a close family member of that person intends in good faith to occupy the rental unit. Basic points of the Residential Tenancy Act. The Residential Tenancy Act is available on the BC Laws website at http://www.bc.laws.ca. The Act is sometimes difficult to interpret. However, it is possible to obtain information regarding your questions by contacting the Residential Tenancy Office in your area. And that's the end of this section. Stay tuned for section 5.